Tonight, we delve straight into the issues from political power plays in the Senate to the deepening weight of debt and looming industrial unrest. Nigeria stands at a crossroad where governance, the economy, and labor all collide. The big question, who bears the cost when the cracks begin to widen? This is Politics HQ. Welcome. I am Dakpo Adigboye. Let's get the answers. Despite the expiration of a 6-month suspension on September 4th, 2026, Senator Natasha Akpoti-Uduaghan has been barred from resuming legislative duties. The Senate, in a letter signed by Acting Clerk Dr. Yaya Danzaria, cited the ongoing appeal at the Court of Appeal as grounds for maintaining the suspension. The lawmaker, who represents Kogi Central, had earlier secured a federal high court ruling declaring a suspension excessive and unconstitutional. But both parties have since appealed the judgment. Until the appellate court delivers its verdict, the Senate insists no administrative action will be taken to facilitate her return. Joining me right now to discuss this is Magaji Mato-Ibrahim. He's the senior advocate of Nigeria. Thank you so much for joining me at this time.
Thank you very much, Dapo, for having me around.
All right. Let me, of course, start this conversation with what you make of the reaction of the National Assembly. Senator Natasha actually did write to the Assembly, to the House, stating that she was due to return on the 4th of September 2025. And I mean, just for formality's sake, she requested that all rights and privileges as a member of the Senate, be restored and the suspension lifted. However, the National Assembly did, of course, respond. The Senate did respond. I would like to read an excerpt of that letter, so that we can actually break this down. I'll move to the second paragraph. The letter has notice of resumption. In it, it says, I am further directed to inform you, that's in response to a letter, that your suspension was with effect from Thursday, 6th of March 2025, if the copy can come on screen, and draw your attention to the fact that the subject matter of your suspension is presently before the Court of Appeal. The matter, therefore, remains sub judice, and until the judicial process is concluded and the Senate formally reviews the suspension in the light of the court's pronouncement, no administrative action can be taken by this office to facilitate your resumption. Basically, what the House is saying is that until this case is resolved in court or there's a verdict on it, she can't resume. Are we looking at some sort of legal bottlenecks or, drags here?
Well, Mr. Dapo, speaking as a lawyer, I think the subject matter is very simple and straightforward. You see, if after the suspension by the Senate, distinguished Senator Natasha did not challenge the matter in court, and it is now 6 months, automatic resumption to the Senate, unless, of course, something else has come up. But having gone to court to challenge the suspension, and of course, a verdict was even given, which the National Assembly was not very okay with, and have gone on appeal. To me, that is not a ground, unless, of course, beyond the appeal, there is maybe a pending application seeking for an injunction to restrain the execution of that judgment. Otherwise, a mere appeal cannot serve as a stay. So I will fault the letter by the clerk of the National Assembly that because there is pending appeal, that the judgment of the court
Barrister Mato-Ibrahim, are you there? I think we seem to, of course, have some sort of connectivity issues with him.
Does not
okay, we
operate
have
as
him
a
back.
stay. Yes. So an appeal does not operate as a stay at all.
All right. So for you, the response by the National Assembly, you said you would rather fault it as a bit of overstay according to the terms of the law. Is that what you're saying, sir?
Yes, because the law is clear. Yes, you have your right to appeal any judgment that you are not happy with, you're aggrieved about. You have the right to appeal. But while you are appealing, the judgment which has been delivered or handed over has not been set aside. What is there now is that there is an appeal challenging that judgment until the decision is taken by the appellate court saying that that judgment that was handed over by the trial court is wrong. That judgment has to be obeyed. That is the standard. That is the law. So the point I'm making is that probably he is speaking or he wrote the letter omitting a vital part, which is maybe there is a pending application saying that we have appealed already, telling the court that we have appealed, and then we're asking that the execution of this judgment, which we have appealed against, be stayed. Unless there is something like that, then you cannot say because you have appealed a judgment, which is declaratory in nature, that you cannot give effect to the judgment that has been handed down. So that is wrong, legally speaking.
So, I mean, is it within the rights of Senator Natasha, irrespective of this response, to resume her duties in the House, if she chooses to?
And if you got me right, like I said, if there is a pending application which she was served, asking the court to stay the execution, then she cannot, because she went to court and then they are not happy with the judgment. They have gone on appeal. If they have filed a motion to say stay the execution of the judgment, until that motion, is taken and heard and determined one way or the other, the judgment stands suspended. But if there is, in the absence of that application, it is within her right to go back, and it is also not proper for the National Assembly to stop her from going back. More so that there is a judgment that have declared the suspension, the 6-month suspension, as excessive, and then the denial of the rights of the constituent that she represents. So whichever way, probably that has not been taken into effect by the clerk of the National Assembly, but if it has been taken effect and that there is no motion filed by their lawyers, then of course they have no right to, they are wrong, to stop her from resuming her duties, having spent the 6 months and then also having obtained judgment of the Federal High Court. But ordinarily speaking, on the other dimension, you see, having gone to court and there is an appeal, and there is also a motion asking for stay of the execution of the judgment of the Federal High Court, of course, it is only proper that we await the outcome of whatever verdict that is coming out from the Court of Appeal, after which, of course, if that is not even done well with any of them, either of the parties, they can still approach the apex courts for final determination. Now, the only challenge here you see, Mr. Dapo, is that the system, the legal system, has to be worked upon in such a way that issues, matters of this nature, because it's not about Natasha herself, it's about the people she represents. I would have thought that this should be given an expeditious treatment in a way that the matter at the trial court and then at the appellate sessions would be heard expeditiously and determined, so that the rights of the people that she represents will not continually be thwarted.
I mean, because that of course will lead me to my next question as regards her role as a senator representing a constituency. This is beyond her as an individual. By extension, she was voted in by a set of people to serve their interests. Yes, she might have had issues with certain persons within the House, which has snowballed into this. Many have asked, as regards even the constitutionality as regards her suspension, if at the end of the day, it's not, in a way, it doesn't contravene the rights of people who put her there. So you talk about the role of the judiciary in this. If you were to suggest, maybe a better way to resolve matters like this, how would you put it?
Yes, if I'm to give a suggestion and then the suggestion will carry weight, I would expect that matters of this nature, particularly not having to do with an individual, but having to do with a whole lot of people who have been desperately or who have been denied right of representation in the National Assembly, the time for doing all this should have been abridged in such a way that the matter would be given an expeditious attention so that the appeal and whatever is pending should be heard and determined expeditiously so that the right of the people will be determined in this matter. So just taking away the issue of Natasha herself, Senator Natasha, with all due respect, but she represents a group of people. And these people, by her being absent in the National Assembly, in the red chambers in particular, they have been denied proper representation, which is their right given to them by the Constitution. So expeditious treatment of these matters should be given. But then speaking honestly, let's leave whatever legality or legalese aside. We can outgrow all these things. A nation cannot move where people carry their personal issues and then taking advantage of the offices which they occupy and then are fighting personal and private battles. So if you look at the case of Senator Natasha, it's something that should have been settled privately, not using the office of Mr. President of the Senate to take advantage of the office or the chair which he occupies, and is using the office to settle personal scores with her. So this is actually not something that will mean well for the nation. It's also not something that will take us to the promised land as a nation. But I think we are growing in such a way that by now we should be able to get out of all these mundane way of handling situations in Nigeria. And so it's not anything that somebody will be happy with at all. No matter, yes, the paper, the letter written has stated that they have appealed. You can see that this is not really a positive move, even from the National Assembly. But for whatever reason they are doing that, all right, I think it's not helping the nation at all.
All right, Barrister Mato-Ibrahim, before, of course, I let you go on this one, let's look at the role of the judiciary generally beyond this issue right now, particularly when it comes to politicians and politics, but pari passu. One would, by arrangement, it's expected that the judiciary is independent. But we have seen cases where, in the case of Nigeria, it appears to be an extension of some arms of government, aside standing alone. That's the perception of some, given some events they've seen, where politicians, after they go to elections, and then they're not comfortable with the results, they take it to tribunal, and they hope that, of course, when it goes through the process, the legal processes, it turns in a certain direction, given the evidence. But at the end of the day, it turns out where results are obtained and all of that using judicial pronouncement. So my question basically to you, sir, is this. Looking at Nigeria's legal system right now, the judicial system, is it really, really helping the polity and politics?
Okay, Mr. Dapo, you and I know that perception might not always be a reality in life. So while people are entitled to their opinion about the judiciary and then having their own perception, whether rightly or wrongly, I still insist, because I have to talk from my background as a lawyer that believes in the justice system. I still insist that the judiciary is actually doing great. I'm not trying to say it's a perfect system, but you and I know that the burden of the judiciary is beyond what we see, is beyond what the general public see. Matters come before the courts, and matters are being treated according to the law and procedure. Now, people out there might not appreciate some of these nitty-gritty of how the judiciary operates. The perception of the public might be they look at it in that direction, but the law might also not look at it from that direction. And then it depends on what is brought before the court. You know, as a judge, your personal knowledge of a matter does not really matter. You might be there, you know the truth about a certain issue that is presented before you, but you are not expected by law and constitutionally to use your personal opinion to deliver a judgment. So at times they are caught up in this quagmire where what is before them is not sufficient enough to take the position that will align with the general public.
All right.
So it's not always about what people think. People are free also to think the way they want to think, but we also have to be fair to the judiciary and understand that the judiciary do not bring evidence before them. The judiciary do not make addresses before them. The judiciary do not cross-examine witnesses. The duty of the lawyers representing the parties to present their case in such a way that the judiciary will be given opportunity to take a proper position of what the law says.
Barrister Mato-Ibrahim, thank you so much for your time. I mean, if you can just respond to this in 30 seconds, briefly.
Yes.
If you were to make a recommendation for just one reform in Nigeria's judicial system, what would that be?
The basic thing, Mr. Dapo, is that judges should be appointed on the basis of merits. What is killing the system is that we have all manner of personalities who are manning the bench, who don't have the basic qualifications to do so, or because they are children of this person, brothers of that person, they are all being brought into the system, and what the result we see is a mess. So that is the basic advice I have. Judges, these are people who represent God on earth. So you cannot just take anybody anyhow based on sentiment. In fact, if they know the burden that is on their heads, accepting to be judges, to be God's representative on earth, you'll be looking for people to appoint as judges, and you will not find. But what we have here, we have even situation where people bribe their way into becoming judges, or then people politically make their way into becoming judges, or if they have their political godparents, they get them into the system. And you cannot give what you don't have. That is a basic principle of law. Nemo that God none abet. There is no way you go, you are empty-headed, you are a corrupt person before you join the judiciary, and then you suddenly go to the judiciary and become an angel. No, you'll be a true representation of who you are before you join. And that is what the system is suffering about.